about. So what will the court do first? In my opinion, the first thing the court will look at, and the first thing the court's concerned about, is the children. So really, the adults can take care of themselves. The court wants to make sure the children are taken care of and that they're properly placed and cared for and that there's enough money and or support for them.
How does that happen?
So, well, the parties have the first shot at it, and we talked before about mediation, so if the parties can work it out themselves or work it out through mediation, that's their best bet. If they can't, and they bring it to the court to decide, the court's going to look at certain factors. It's laid out in a case called Patinato, which the Patinato factors, which long and short of it, the bottom line is what's in the best interest of the child. So if you're going to go through a custody battle and have a hearing on that because the parties can't work it out, the judge is going to listen to testimony and want to hear factors about a number of things. Placement of children is actually a very interesting thing too, because that's evolved over time. We'll talk about it a little bit historically. When I started back in the prehistoric days, the mom was usually considered to be the person who should have custody of the child.
I think the percentage, the statistic with that is about 91% of cases the child resides with the mother.
Right.
Is that still the case?
I don't know. I think it might be a little bit less now.
Less than that, a higher percentage maybe than moms or dads. But when I first started, we usually talked about sole custody. The mom had custody, the father had visitation. And that's the way it worked. I'm going to say at least up until the early to mid-'80s. There was also a doctrine which may or may not be in favor today, depending on what judge you're in front of.
Tender years doctrine.
The tender years doctrine, which is if the child is particularly a younger child, then...
Meaning 12 or under?
No.
Even younger.
Under 2, under 3.
Right, that child also belongs with the mom as opposed to the dad. This has really changed a bit over time. I had a case where I was suggesting to the judge at the time that it should be a joint custody. And at that time, they didn't want to hear about joint custody. It wasn't understood what it meant, what it is. And it didn't necessarily mean that the parents were going to share physical time with the child, but it's developed, and now I would say it's probably the main resolution. All things being equal, each parent has the legal right to speak to doctors, to have educational records, to have input into major decisions. That's what we really mean by joint custody.
Yeah, what David's talking about, the differences in custody, Massachusetts, we commonly refer to that as legal custody and physical custody. Joint custody in Rhode Island means that you have joint legal custody. The difference between the two essentially is that with legal custody, each parent has the right to participate in major life events concerning the children. Health, education, welfare, religion, any major life events. So they are still the parent. It's not denying anything. They're not losing any rights. Conversely, with physical custody, that's actually where the child resides. So similar in Rhode Island, except we delineate between the two, joint physical, joint legal. You need to point that out. Usually with placement, my experiences with placement, it is still with the mother. However, I've had a number of cases in the past wherein the children are actually with the father.
50-50% of the time?
I've had a couple that are 50-50, although the courts are a little suspect with that because sometimes a parent would want a 50-50 placement because they feel that child support would be eliminated. There would be no need to pay child support if it's 50-50 placement. In Massachusetts, that's not true.
In Rhode Island,
it's not true either. So people are under this impression that, well, we're going to have 50-50 placement. I don't have to pay any child support. You know, I always tell people, judges don't fall off turnip trucks. They see through everything. Right. They've been there. They've done that, and they were probably family court practitioners prior to taking the bench.
So in Rhode Island, joint custody, you still need to have physical placement somewhere.
Yes.
Usually, as Jackie says, a lot of times it's the mom, it can be the dad. They have to look at the factors to determine
what's in the best interest of the child.
Exactly. And also, as you were saying, how old is the child? Now, if the child's a little bit older, Rhode Island law does allow some input from the child, a 14, 13, 12-year-old child, even if they're mature enough, to have some input into where they think they should live. But the judge won't rely solely on what the child thinks. There's a whole multitude of issues and circumstances that the court has to look at.
We haven't spoken specifically about divorces. Divorces are final, but when you're talking about this issue, does that decision become final, or does that get revisited, for example, when, say, the husband or the father's work situation changes and he needs to move out of state, and whatever they had formerly had for a physical arrangement perhaps won't work? Do they renegotiate that after? Or?
Anything pertaining to a child in a divorce or even a non-divorce case, maybe a paternity case,
right.
it's always subject to modification because times change frequently, children get older, it's always subject to modification. There is no contract that you can write that says this child is going to remain 100% with mom 100% of the time. Things change.
The court retains jurisdiction
They always
over
retain jurisdiction,
any issue
so
with
you can modify
the child.
it.
The minute two people or one person decides this marriage is over, we're not doing counseling, we are going to be divorced, what's the first thing that has to happen? Does the person have to go to a lawyer first, or can they file their own papers? Do they? How do they?
It's not always advisable that they do it on their own. However, if for instance, in Massachusetts, they do have lawyers of the day, which means that a couple times a month, there is a lawyer that is present in the courtroom who does it as a public service to the community, and they will sit with the individual or individuals and show them how to fill out the paperwork. Now, if it's an uncontested case, it's really not that big of a deal, but they need to know what they're getting into, okay? And in Massachusetts, if you're going to be filing an uncontested case, you also have to have a property settlement agreement with it. And that's true in any case in Mass. You will not get a divorce unless you have a formal contract that spells out your settlement regarding assets, custody, visitation, income taxes.
Do you need that when you first file?
If it's an uncontested case
You
in
do.
Massachusetts, you file it under what's called Section 1A of the divorce statute. It has to be filed as a joint petition. You're required, if there are children, to attend parent education classes, so you have to include in your petition parent education certificates. You also have to have a financial statement for each of the parties, which is a listing of income, expenses, assets, and liabilities. You also are compelled to have a property settlement agreement. Without it, you're not going to get divorced, and they're going to put it on what's called a 1B track, which is a contested case. In Rhode Island, you want to talk about it a little different in Rhode Island.
We don't have lawyers for a day.
Yeah, they should.
Yeah, for a
Another
lifetime.
shout out to the.
We do, however, have a
How
fairly
is that
large panel of volunteer lawyers and a volunteer lawyer program through the Rhode Island Bar Association, which handles a lot of family court matters. The issue, though, is if you want to represent yourself, you can. You have a right to do that. However, the judges will tell you they're not on the bench to be your lawyer. You have to know what you're doing and be able to put through the divorce when the time comes. It's not an easy thing to do. If it's an uncontested divorce, it's probably worth your while to hire someone to represent you. There's a lawyer, I may have mentioned this before, who said that when someone calls him up and says, "Can I represent myself?" he says yes. You can represent yourself, and if you want to do surgery to yourself, I've got a little package I can send you which gives you the instructions in a mirror.
Ill-advised.
Right, exactly. It's ill-advised to go to court on your own. It's ill-advised to do your own surgery.
Not only that, in Rhode Island, there's a process of putting through a divorce once it's completed. Call it an uncontested divorce. When you've reached an agreement, you need to put on the record that we're getting divorced and that the agreement is fair and reasonable. They actually take testimony in Rhode Island. So you need to learn how to put through a nominal. So you've got to have two witnesses to identify that there's a domicile
And irreconcilable
and
differences.
irreconcilable differences. You also have to prepare your own court order in Rhode Island. And if you don't know how to prepare your court order, some of the judges are telling you, if you can't prepare your court order, the court's not going to do it for you, so you're going to have to either figure it out or hire an attorney. In Massachusetts, we don't actually have to put testimony on to the extent that they do in Rhode Island for a judge to hear the divorce. Essentially, it's really, the first 5 questions of the complaint, which is the name of the parties, address of the parties, the last place they live together, the number of the children.
Grounds for divorce.
And the grounds for divorce. And remember, you have to have that settlement agreement before the judge, so the judge has that agreement in Massachusetts to review, and that's the last thing you want to ask them is if they sign the agreement freely and voluntarily.